That's fine. We'll just get started with, well, there's a couple of...
The only thing has somebody got their 2 laptops with sound on? Because it sounds like there's a wee bit of feedback there.
There's definitely feedback. I don't know. We've only got one.
I'm not connected.
Oh, it seems to have died down now, so I don't know what's happened there. Okay.
I'll speak again.
Is it okay now?
Yeah,
that seems
that's
to be
us.
bad. Okay, we're not expecting anyone else. We'll just get started. Good afternoon, everyone. 1 p.m. on Wednesday, the 28th of February, 2024, and it's time to start the hearing. You've all got your camera on. If you could all keep yourself on mute just for now, it prevents the feedback, and we've established that everybody can hear me. So welcome to the hearing session in relation to appeal reference PPA-250-2403, submitted on behalf of Mrs. Linda Tinson in relation to conditions applied by Fife Council to planning permission in principle reference 23/00739/PPP for residential development at Masterton Road in Dunfermline. So we'll start with some introductions, make sure we all know who each other is. So I'm Alison Kirkwood. I'm the DPA reporter who's been appointed by Scottish ministers to determine the appeal. Obviously met some of you previously at the site visit back in December. Mr. Fitzpatrick, would you be able to introduce yourself and the appellant?
I'm Joe Fitzpatrick, and I'm the planning consultant dealing with the application and the appeal. And my client is Linda Tinson, who's basically. Do you want to?
Yeah, I met you, Alison.
I met you at
the farm, yeah,
on site. Mr. Patrick, I think initially you'd said that Ms. Tinson would be attending as an observer, but I noticed at the end of your appeal statement that Ms. Tinson would like to participate as well, which is absolutely fine. Apologies, I didn't pick that up. Is that still the case?
Yeah, well, it's really just from the point of view of Linda's knowledge of the site itself, intricate knowledge of exactly all the bits and bobs that apply here. So, but for all the planning matters, it'll be through myself.
I'll direct the questions to you, and then if you feel that Ms. Tinson's better or has more to add, then you can bring her in. Does that sound okay?
Yeah, it sounds good.
Good. And for the council, who will be the main spokesperson today?
I'm Brian Forsyth, the case officer for the application. We did on site along with the appellant. I'll be speaking to matters 1, 3, and 5, and 1, 3, and 5, and my lead officer Derek Simpson will be speaking to the other matters. Matters 2 and 4.
Okay, that's fine. Now, the way I can see both parties on screen, I'm struggling to see all of you. I don't know whether it was a change of the way the camera was. Mr. Fitzpatrick, I can't. That's better. I can see. Oh, I can see everybody now. Perfect. If you could keep it like that, that would be really helpful. Okay, thank you for the introductions. So this hearing will be webcast live by the DPA. The video recording will be retained on the website after the application is determined. By taking part, you're consenting to be filmed and to the use and storage of these images and sound recordings and any information contained in them for webcasting and training purposes, and for the purpose of keeping historical records and making those records available to the public. Is that okay with everyone? You've already met David from our IT team. He'll be keeping an eye on proceedings and can provide support if we have any technical difficulties. But fingers crossed, all will go smoothly. During the hearing, if you can keep yourself on mute unless you're speaking, and just avoids interference. We're just a small gathering today, so if you need to get my attention at any time, just speak out or wave your hand. But I don't foresee any difficulties in that way. Okay, so I'm just going to briefly run over the purpose and the format of the hearing. A number of you taking part have probably been involved in these before, but also for the benefit of anybody that is viewing on the website. So the appeal has been determined under the provisions of the Town and Country Planning Appeals Scotland Regulations 2013. Having considered the appeal proposal and the documents submitted with it, I decided to hold a hearing session in order to assist my consideration of the matters raised. The procedure notice issued on the 18th of January 2024 set out the matters on which I sought written further information from the Council and the appellant and asked you to submit these in the form of a hearing statement. So thank you for your responses on that. So following this, I issued a hearing agenda on the 14th of February, which covers the same matters, but also adds on a procedural matter as matter 5. That shouldn't take us too long to go over, but I just wanted to seek your views on that. So we've got 5 specified matters that we will cover in turn. The principle of planning obligations, details to be included in a Section 75 agreement, the wording of conditions 1D, 10 and 11, the wording of condition 3, and finally the implications of Section 48 of the Town and Country Planning Scotland Act as amended. So matters 1 to 4 were you covered in your hearing statements, and you'll have the opportunity to comment on points raised in each other's hearing statements at the end of each section if we haven't covered those under earlier discussions. No other matters relevant to the appeal will be considered at the hearing. However, I will be taking account of all the appeal submissions, written representations and consultation responses. It's just that these aren't matters that I consider I need further information on during the hearing. So hearings are a way of allowing each party to put forward their point of view while also letting me get the information I need to reach my decision. The hearing procedures set out in Circular 4/2013, which indicates that the format will be a discussion, which I will lead. The procedure is informal and there'll be no cross-examination of witnesses. The points on which I require further information under each matter are listed in the agenda. Do you all have a copy of the agenda? Excellent. So throughout the hearing, I'll invite participants to contribute at appropriate times and give each of you the opportunity to comment and to ask questions. I'll be taking notes, so I may ask you to slow down or repeat something if need be, but I'll do my best to keep up. But if you could just try to avoid speaking too quickly. Please don't interrupt or speak over another party. You'll all have the chance to comment and to ask relevant questions. And where you want to ask questions of the other party, they should be addressed through me. As you're aware, I've already visited the site and the surrounding area. I don't envisage that a second site inspection will be necessary, but I'll make a final decision on that after I've heard today's evidence. I'm not quite sure how long we'll take today, but we'll take stock at around 3 o'clock and take a break then if necessary. But if anybody wants to pause proceedings at any point, just let me know and we can take a break. It's not a problem. So finally, a few housekeeping matters. Parties should use their microphones, making sure to turn them off every time you conclude speaking. this is required to allow the recording to switch to the person speaking. I guess just to reiterate that pauses may be needed to allow people to get documents or to follow the evidence. So we'll just take it at the pace we need. Is everyone clear about these procedures? Does anyone have any questions about them or any matters they want to raise before we get started? Okay. We'll get started onto the agenda then. Okay, so matter one relates to the principle of the planning obligations. This really within the context of 5 Plan Policy 4 and paragraph 3.7 of the Planning Obligations Framework Supplementary Guidance. So it might be quite useful if you have those to hand. So I asked in the procedure notice for each party to provide me with a plan of what they considered to be the extent of brownfield land on the site, and thank you for doing that. So the council considers that 5,336 square metres of the site is brownfield, leaving 6,222 as greenfield, based on an overall site area of 11,556 square metres. I calculate that to be a sort of 46%, 54% split. So 46% brownfield, 54% greenfield. The appellant considers all of the site, with the exception of the woodland in the west, is brownfield. And as the woodland area is to be retained, all of the developable area is considered to be brownfield. So based on that, my understanding is the main area of contention appears to be the sort of the northeast section of the site, which is the area that the appellant refers to as the stackyard area. So within that context, 5 Plan Policy 4 states that developments will be exempt from obligations if they are for the reuse of derelict land or buildings, previously developed land, or the rehabilitation of contaminated land within a defined settlement. Paragraph 3.7 of the Planning Obligations Framework Supplementary Guidance provides further detail and lists as an exception to the policy the reuse of derelict land or buildings, brownfield, which is defined as previously developed land within a defined settlement, excluding sites currently occupied by operational employment uses, former mine workings, and naturalised previously developed land. And the LDP glossary provides a definition of brownfield as land which has been previously developed. So what I would like to start with was asking parties in turn is whether they consider that the northeast section of the site has been previously developed. I ask the appellant first, Mr. Fitzpatrick.
Yes, so yeah, definitely. It's basically it was an integral part of the overall farm operations. There's concrete plinths there. There's silage pits. There's basically, although there was no actual buildings on it, it was an integral part of the farm operations. There was there's vehicle tracks on it as well. Admittedly, there's a small area in the very northeast up next to the wall, which might be considered to have been naturalised, but it's very small.
Can I comment?
Okay.
But yeah, by way of context, in the winter months when the machinery was taken out the sheds to allow cattle and storage of crops and potato dressing and everything else in the sheds happen, all the machinery and things that would be stored in the summer inside the sheds is taken out and put in that area. So it was very much an important part of the farm to be able to put the machinery outside in that area and also store, it's called the stat yard because it would store the fodder as well. And as Joe says, there's a concrete area, which was the silage pit, which is, it's all concreted up there, turning areas for getting in and out the silage pit, etc.
Okay, that's helpful. I'll ask you a few more questions and then I'll come in and get the councillor's view on that. So my follow-up question was, which Mr. Fitzpatrick partly answered, was is it naturalised previously developed land? So you said you thought that there was a small part in the northeast corner could be described as naturalised, but is that the only part of the
Yeah.
site that's?
Yeah.
As part of the appellant's hearing statement, you provided a photograph for the parties have that.
Yeah.
Could you maybe describe to me what you want me to take from this? Because you've basically said it provides evidence, but it would be helpful if you could provide me with a wee bit more of an explanation of what's going on in this photograph and what I should be looking for.
Well, the area that is adjacent to the shed, basically, it's as Linda was saying, this is when all the material is taken out of the barns in order to stock it, to make room for the use of the structures themselves. So you can see that a significant large area of that is just used as part of the farm operation, the farm holding.
It's not showing up very well because it's a bit blurry because it was quite a far away aerial picture. It was the only one I could find, but it shows around in a sort of semicircle the machinery. It would be placed along sort of in from the wall all the way around, so you could reverse your tractors in and take the machines out. Yeah. And the area where you can see it looks a bit like a wall, that's the silage being stored and the hay and straw being stored on that concrete plinth so it doesn't get wet, basically.
Okay, thank you. I'll bring the councillor in on generally, but does the council have any questions that they want to ask the appellant about that photograph? Is there any clarification that you want to ask on that? Or
would the appellant acknowledge it isn't particularly clear what is shown, and does the appellant have a date for the photograph?
Be able to answer that for us?
I don't have a date, but looking at it, I think it's probably, well, I know the farming operations changed in the late 90s when we didn't have as many cattle. So it's probably, I don't know, well, it could have been 2000s because we didn't have cattle, but our neighbours used it as their cattle storage. So I actually wouldn't know.
I think the key point on that is that the date of the photograph isn't necessarily the relevant thing. It's the date of when, that area was last used, and it's basically in active use from time to time.
And the farming partnership itself didn't wind up until 2016, I think. So we were farming here actively until the land was sold at 2016.
Yeah, but you're also providing a facility for a friend.
Yeah, we have a friend at the moment whose sheds were flooded and has got his cows in there this winter, and he's storing his fodder as well up there.
think we saw there was
Yeah.
there was cattle on the day that Mr. Forsyth and I went to on the site visit. I think you had calves that day. That was the excitement.
We have
But,
some more. Yeah.
Okay, and well, I think you said at the start that you felt that accepted that the photograph wasn't particularly clear in terms of what was going on, but we've got silage about the wall, and is that vehicles within the centre? Is that?
No, it's the other way around, actually. The silage is on that the concrete plinth is in the centre.
Right.
And round the edge would be, I think when you were there, actually, he has parked his machines up where you would traditionally have put them round the wall so that you can reverse your tractors in and take them out on that circular vehicle route. So they can get in and out with their, toppers or their balers and things like that.
Okay, thank you. That's helpful. Anything else the council want to ask about the photograph, or can we move?
No, we're ready for your questions.
Okay. Let's just ensure that I've got everything from. Okay, so from the council's point of view, then the same question in terms of the northeastern part of the site. Does the council consider that part has been previously developed?
Very largely, no. I think the main clue as to it not having been previously developed is the reference in the appellant's hearing statement to the area having been a stack area. The use of land for agricultural purposes doesn't involve development of land in terms of the Planning Act. So it's difficult to see how this stack area, which is described for the laying down of supplies, the siting of farm machinery and equipment, and the circulation of vehicles, can be considered previous development. I've looked at the historic Ordnance Survey mapping on the National Library of Scotland's website, and there's nothing shown in this area other than a ducat in the late 1800s, and everything the appellant and the agent has said this afternoon only serves to confirm our view that area has very largely not been previously developed.
Okay, thank you for that. Is there any part of the site which would fall within the description of naturalised, previously developed land?
From my view of the area from during our site visit, I would say any parts of that area which might be considered previously developed have been naturalised. I would respectfully suggest anyone who was asked, does this area look as if it's been any previously developed areas look as if they've been naturalised? I think they would say, on balance, yes.
Thank you. Does the appellant want to come back on anything like that on what the council has said in terms of the council's position on the previously developed?
Yes. Yeah, please. So I'll bring Linda in a minute, but really to argue, this is agricultural and almost stating that like it's been a field and therefore cannot be considered brownfield, it isn't really the case. This hasn't been for production of crops. It's been an active area. Okay, there weren't any buildings on it, and we accept that, but it has been an active area. It's previously used land Now, the evidence to that is that there's the concrete area for the silage pit, and there's also a large plinth, concrete plinth area on the site for where vehicles would as a hard standing area. Now, we do acknowledge that in the northeast crescent of it, and you can see that in the photograph, in the northeast crescent, beyond where the machinery is lined up around the edge of the path, there's a small area that could be argued as having become naturalised, that wasn't an active part of the farm operation. Just because there isn't any buildings in it doesn't mean.
Just so I'm clear, so looking at the photograph, there's the area of what looks like the circulation track, is it?
Yeah, that's right. Yeah. So it would be the area.
We're really talking about this
top left,
triangular shaped.
Yeah.
Well, there we go.
Yeah, but just
That
and not that whole area. That's not, because you can see the machinery stacked on that. It's at the back of that area. It's the light portion at the back. So a small semicircular area.
Yeah, that's effectively dry grass. I think that's, it's only because it's slightly inaccessible with it being a corner rather than any other reason. And the other thing I would say is that it is ancillary to the use of the steading. And if you look at the definition of steading, that includes stackyard, and it had business rates payable on it as well. The whole amount, the whole area, we used to pay business rates on this. There was business water supply. We have historically, the family have been here since 1939. There was a village. Those buildings are actually, there was a village school at the top there, and a farriery. So all these, I'm not sure where the OS maps are. Maybe they're even older than when the village was here, but we do even have a register of people who lived here in the war, from my great-grandfather being the ARP warden. So there were lots of buildings up there. It is very rubbly. Even the bits that's not recently concreted, it's very rubbly. It's not in any way cultivatable as agricultural land. You couldn't even graze a livestock up there. It's very pitted.
I think because what I'm trying to do is, in terms of the definitions, my starting point has to be what's in the development plan, which is why I'd set out that context. So, what the definitions talk about is previously developed land, and the definition of brownfield land being land which has previously been developed. So I think there's different evidence coming forward, and I think as well that the guidance, the onus is on the applicant to demonstrate that, to provide the evidence of the brownfield to greenfield, and I'm comfortable that I've got that evidence. Your views on that before me, and I'll need to take a view as to whether or not I'm persuaded by the evidence submitted by the appellant. I suppose linked to that, it would maybe be helpful to move on to item 1B. We can come back if there's anything on the split the definition if anybody needs to. But I was really trying to understand the implications, the reason why that we're having this discussion about the brownfield and greenfield parts of the site. Relates to the footnote at the end of paragraph 3.7 in the Planning Obligations Framework Supplementary Guidance. And that states, where a site is part brownfield and part greenfield, obligations will be sought for the greenfield element of the site only. So question raised for the council on that point of view. What are the implications of that footnote for the appeal proposal? We'll get into the details of wording of conditions and what needs to go into legal agreements under under further items, but it's really in principle, I suppose, what's the council's view? Does that footnote have implications for the approach to be taken to obligations for this site?
We would certainly argue yes, if you'll excuse me from just drawing on my notes here.
Yeah, no, please do.
As explained in our hearing statement, the council's position is that collectively, the 5 plan policies 1 and 4 and the framework guidance, including the footnote you referred to, exempt the development from obligations towards education and strategic transportation intervention measures, insofar as the proposals would involve the previously developed part of the site. That is involved dwellings on that part of the site, or where overall development of the site would be for fewer than 10 houses. In terms of the framework guidance and that footnote, the council's position is that exemption from obligations in terms of education and transportation wouldn't apply in the case of previously developed land, which is now naturalised, because that would be greenfield. Is that right?
Yes, I think that comes back to that bit that I read out previously as in terms of the exemptions in paragraph 3.7 of the framework that says it excludes sites currently occupied by operational employment uses, former mine workings and naturalised previously developed land. So I understand where the council is coming from on that point of view. So I think we'll come on to the details of the wording, because obviously the existing wording of condition 1D appears to exempt contributions from the brownfield part on the strategic transport, but it doesn't make that clear in relation to the education. But we'll cover that when we look at the wording in detail. Does the appellant wish to comment on that? I understand the appellant's position is that that all of the site apart from the woodland area is brownfield, and you wouldn't be proposing any housing on the woodland. Is my understanding correct of that?
Yes. So we're arguing that everything apart from the woodland is brownfield, because under the definition it's previously used land.
Previously developed land, I think.
Sorry,
have to think.
previously developed land.
The definition is previously developed, not necessarily previously used, but I'm clear in my mind that that's what I need to look at.
So the other aspect to that is the further question as to the extent to which we consider an area may have become naturalised, which is much more limited.
And the woodland, yes, there'd be no development on the woodland. It is a sharp, I think you saw it on your visit, a sharp drop, and the trees are laid in very close to that sharp incline. There's no developable area there.
We walked down into the woodland, didn't we, in terms of, so I could get an understanding of that. So that's helpful. Okay, I think I'm comfortable on the position of both parties on that. I want to give both of you the opportunity to comment on any other matter arising for the hearing statements in relation to the principle of planning obligations, if you wish. Mr. Fitzpatrick, is there anything that the council said in relation to that matter that you want to draw my attention to?
Yeah, so I'm not sure if it's appropriate to raise this at this time, but there seems to be a discrepancy in the figures that have been supplied between what the report of handling says and what the council's appeal submission says in terms of the relative proportions of green and brownfield land. Under the hearing statement provided by the council, the site seems to have increased in area by 304 square metres. And it was really just to try and understand why that might be the case. So the greenfield element has risen from 5775 in the report of handling to 6220 in the hearing statement. I'm not sure why that should be the case.
Okay, well, I'll ask the council that on your behalf. Mr. Forsyth, are you able to?
Yes, I freely acknowledge there's a discrepancy that can perhaps be explained by I think the figures. The discrepancy can be explained with the figure in the hearing state. Our and a figure in our report of handling, rather, the most recent report of handling relates to the figures that were cited in the report of handling for the 2018 application. And I think those were understandings of the split at the time. But I've now had a chance to review it in light of the, what I've seen on site, and using technology available to me, I've revised those figures as set out in the hearing statement. I would put you that figures in our hearing statement are more accurate than the figure quoted in the report of handling for the current appeal application.
Okay, thank you for that. So it's the council's view that I should use the figures in the hearing statement when I'm referring to the council's position. That. Okay, thank you for drawing that to my attention, Mr. Fitzpatrick. Anything else in terms of the council's hearing statement on this matter?
Yes, so we're focused basically on the council's intention to consider the stackyard as being the greenfield land, but there are other aspects of the development which they've included as greenfield land, which quite clearly aren't. There's on the plan that they've supplied.
Okay, so I've got this plan here. Yeah.
Yeah, you can see the track to just separating the woodland area from the buildings.
Yeah.
That's a tarmac track and a type 1 track. And it goes right round and links over to the north of the building into the stackyard area. So, and all the way down to the south where it links in with the track at the bottom, which, okay, the council has included that aspect of the track within the brownfield area, and that's acknowledged. There's also a section to the south, the southeast. There's a rectangular area there. Now that's hard standing for car parking. It's not
in storage for the cottages are on the main road. In fact, where you parked your car.
I think that's where I parked. Yes, wasn't it?
Yeah.
So that's not greenfield. So
it's got the council gritting bucket there and the buckets for the cottages, car parking space for the cottages, and it's actually the old foundations of a cottage that was knocked down on the corner there as well.
Okay, the council want to comment on that?
Yeah, there may be some minor discrepancies, but from my having visited the site and taking into account that the farming partnership hasn't been active since 2016, my recollection was that the area of access trap between the farm buildings and the woodland had naturalised to a degree over the period since 2016. But I mean, ultimately, Mrs. Kirkwood, it would be for you to decide based on your site inspection and the evidence you've heard today.
Yeah, I was just sort of, I mean, one of the conditions, I think it's condition 1L on the permission requires a detailed plan of a scale not less than 1 to 500 showing greenfield, brownfield portion of the site. Now, the appeal doesn't relate to that condition, and the condition doesn't actually require that plan to be agreed, so I'm not too sure of the council's intentions of that, but that is perhaps a matter that can be addressed between parties through approval of matters specified in condition.
Sorry.
I think my main role is to establish whether or not the site is all brownfield and therefore there's no requirement for any obligations, or it is a site which has a brownfield greenfield split and therefore the provisions of the framework in terms of what parts of the site obligations are required to. So I probably don't need to go into the exact details as to how much of the land is brownfield greenfield beyond that principle, but it is something that I will give further thought to after the hearing. And certainly I have the plans and the points made by the appellant on those additional areas of the hard standing and the track, as well as the stackyard. Is there anything else anybody wants to raise in relation to?
It was just to agree with the point that you make that the split is ultimately more properly for the to be considered as part of the application for approval of matters specified in condition. Although it's not irrelevant to your consideration of the appeal, the fine detail of the split.
Yeah, unless it's all considered to be brownfield, which is then takes us in a different direction. But no, that's been helpful to explore the nuances of that together. Does anybody want to raise anything else under matter 1?
No.
Okay, we'll move on to matter 2. So under this one, what I want to focus on are the contributions that have been listed in condition 1D. I included these conditions in the agenda, so we all have them to hand. Further on in the hearing, we'll discuss the mechanism in terms of how best to secure these if there is a justification for them. But in terms of this matter, it's trying to get and understand the justification for and the extent of contributions. So condition 1D indicates that Section 75 agreement shall include an education contributions towards the cost of mitigation across Dunfermline secondary schools, a strategic transport intervention contribution of 5,332 per each dwelling located on the greenfield part of the site, and a 25% affordable housing contribution. And I asked parties to provide me with their views on the justification for these in your hearing statements, which was helpful. It would just be useful to look at these individually in a little bit more detail. So if we start with the education, so I've been provided with the education consultation response to application 22000984 PPP dated 23rd of June. And I think then the response from education to 23000739 PPP dated 18th of May 2023, which refers back to the 2022 one. And those are all being set out within the context of the planning obligations framework guidance, as far as I can understand. So the response from education sets out the catchment areas for both denominational and non-denominational primary and secondary schools, but I note that the only contribution being sought is towards non-denominational secondary education. The plan considers that the proposed Dunfermline Learning Campus, due to open in 2024-2025, will address current capacity constraints, thereby removing the need for developer contributions. However, I note that paragraphs 5.36 and 5.37 of the obligations guidance refer to retrospective education contributions. Can the Council firstly help me understand what the implications of those paragraph 5.36 and 5.37 in terms of retrospective education contributions for the appeal proposal? Perhaps you could help by sort of explaining where the context of the Dunfermline Learning Campus, first of all, is that just to help me understand where secondary provision is going in Dunfermline.
Yes, thank you. The Dunfermline Learning Campus doesn't provide any additional capacity. That's the Dunfermline Learning Campus deals with the Woodmill High School, a replacement for that. So it's not that the Learning Campus would provide any additional capacity over and above the capacity considered through the obligations guidance. So it wouldn't be correct to say that there's other capacity there. With regards to the catchment areas are different from the maps set out in the obligations guidance. They have changed. I think it was around about 2019 that was done. So they have changed. So the site is within the Dunfermline High catchment area, but as set out in the obligations guidance as a catchment, multi-catchment Dunfermline wide approach taken, and this site has always been factored in to those considerations in terms of the overall required capacity for Dunfermline.
So is it relevant to my consideration that the catchment's changed? Is there a capacity issue at Dunfermline High School?
I think because the way that the obligations framework sets out how it's calculated, because it's catchment wide, it doesn't change.
Right.
There's no critical capacity issues, so there'd only be education contributions on the greenfield element of the proposal, not on the brownfield. That would be exempt. So there's not a critical capacity issue. It's just for any development on the greenfield would be subject to the secondary school contributions for a catchment-wide solution. It's also, I think, worth pointing out that there's obviously the reference there to a new high school and a £36 million costing associated with that. Again, things have moved on since 2017, and there was a paper put before Fife Council which was looking at alternative solutions to that, and that's getting worked up at the moment. So the current approach is for extensions to the existing school networks rather than a new school to deal with the capacity issues. But the issue with capacity is unchanged in terms of there's still the need for additional secondary school capacity. It's just that the solution now being looked at is moved on from what was highlighted as the probable solution at the time in 2017. But the guidance does highlight the fact that, you know, things can change, catchment can change, use can change, so there is flexibility built into that to allow for that. But clearly, there's work going on behind the scenes to look at the costings associated with that different approach now, and dependent on what the costings are for that, you know, the level of contribution may change. And obviously, if contributions were sought in line with the £36 million costing, and those costings were to change, then in terms of the legal agreement to secure that, it would be built into that obviously the monies would be repaid. We would only take contributions which were directly linked to the impact of the development.
Okay, that's a helpful update. I've got one further question for the council before I come bring the appellant in. So you indicated that the education contributions should only be sought from development on the greenfield part of the site.
Yes.
Should that be clarified in the wording of policy 1D if it were to remain? We have a strategic transport intervention for each dwelling located on the greenfield part of the application site, but
I think it could probably be a bit more precise. I suppose it also takes account of the fact that it's not critical at the moment, but I suppose things could change. But I think, you know, it references directly to the planning obligations framework, which sets out when contributions are required, and it sets out obviously if there's a critical issue, then the exemption on the brownfield doesn't apply if it's a critical impact, i.e. in the next 2 years. But that doesn't apply currently to primary or secondary school education capacity across Dunfermline for this site. It's not critical, so it would only be for so the brownfield element is exempt as it's stated in the guidance, and it would just be for any development on the greenfield that would make a contribution towards the secondary school.
okay, that's thank you for explaining the council's position on that. Mr. Fitzpatrick, would you like to comment on the council's response? Obviously, it's introduced a bit more detail than perhaps we had in the hearing statements, but it does sort of relate to some of the comments that you made.
Yeah, thank you very much. So, yeah, I think basically the point we're making is that the response from Education Services under the previous application doesn't allow any clarity at all on what the exact implications are under the proposals at the moment, and we've made that clear in our hearing statement. Capacity is assessed Dunfermline wide, and it's difficult to understand how the new campus will not fundamentally affect how that capacity issue needs to be calculated for the site. And again, it's all tied up with the extent of the greenfield area versus the brownfield area, which is, I know, something that you will reach a determination on.
Yes, I understand. If we can set that aside, and if I consider that there is some greenfield on the site, then I need to go through these things. So, but I fully understand your position at the outset. So any evidence you give into that isn't weakening your position that that's where you're coming from. But I would appreciate your input to these other matters that I'm going to have to potentially address.
Mm-hmm. Yeah. So until we get clarity, we really can't determine exactly what the implications are for the education contributions and whether they would apply. If you reach a determination that there's an element of greenfield, and we then build houses, or houses are proposed on that greenfield, we then accept that those contributions would be necessary.
Okay, well, I think both parties are in agreement that the education contribution would only apply to a greenfield element of the site if there is any development on a greenfield. So that's certainly helpful from my point of view to understanding where we come from, and where it leads us will depend on our consideration of my conclusions and some of the other matters in terms of whether the condition remains and whether we explore whether applying a Section 75 in advance of issuing a permission is a better way forward. So I've tried to break the matters into sort of individual components, but there's inevitably overlap between them. And if I'm confusing any of you at any point, please step in and we'll go back and recalibrate and bring everybody along. The council want to say anything more, Mr. Simpson, on the education?
Yeah, kind of going back a bit to Greenfield, Brownfield. I know you don't want to labour on that, but I think we're both in agreement that the woodland area is Greenfield, so there is Greenfield on the site, and as it currently stands, there's nothing in the planning permission in principle consent which says you can't develop on that area. So it's obviously clear that might be. I understand that that's not the intentions of the developer or sorry, the applicant, but also that might be something to consider in terms of any subsequent permission. In terms of excluding that area from development, in terms of clarifying if there's any brownfield or greenfield, so just to flag that.
Okay, yeah, I'll just clarify. So what you're perhaps suggesting is that it may be open to me to either add or amend a condition to make clear that there should be no development on the woodland area. Would you like to comment on that, Mr. Fitzpatrick, and then go on to whatever else you...
Yeah, we're happy with a condition saying no development on the woodland area.
Not feasible.
Yeah. The other aspect to, although we'd be making the point that we accept if there is housing on a greenfield element, then an education contribution would be required. The other side to that is that would only be if a capacity issue had been identified. And we're just not satisfied that at the moment there is clarity on whether an actual capacity issue exists.
Would you like me to?
Yes, please. I mean, I think you said earlier that the learning campus is a replacement for Woodmill High School. Is that correct? And it isn't generating any additional capacity. So in capacity terms, the figures are as was in terms of the. Is that correct?
Yes.
Anything else you want to add in terms of providing clarity for the appellant to understand what why a potential education contribution is justified?
Yeah, I mean, I think the assessment that was done in terms of the capacity is still relevant and valid. It's obviously what the solution is to address that capacity issue, I think, is what is still being looked at by us in terms of the best way forward. So, as I say, there's not enough capacity to deliver education requirements for the allocated sites that are in the local plan, including this site, and that has been through sort of rigorous assessment and testing, and but obviously the solution to deal with that capacity issue is subject to change, as I've already set out.
I mean, unlike the strategic transport intervention, the wording in the condition 1D doesn't specify a figure per dwelling for education. So I think I understand that from what you're saying is that if this new work that's taken account of the recent it'll come up with a figure, and that would be what would be expected per dwelling house. So that's a matter that would be resolved through the drafting of a Section 75, whether it's drafted as part of this appeal before a decision's released, or as is drafted in the condition that it's something that has to be done by the appellant beforehand. So I can understand the appellant's concern that there's uncertainty as to what that's going to mean for a developer coming forward. But on the other hand, as you say, it allows that flexibility that it may be a lower amount that is envisaged at the minute.
Yeah, and also the contributions are related to the number of bedrooms in the properties as well. And obviously, you know, at this stage that's an unknown. So there's kind of, you know, again, that's the reason to allow the flexibility there to ensure that it doesn't sort of prejudice the ARC applications coming forward.
Okay, I understand that. Mr. Fitzpatrick, do you want to come back on anything of that? I think I understand the appellant's point of view, but
I think we'll just rest on that. Yeah.
Okay. No, that's education. Then we move on to the strategic transport interventions. So again, I've got been provided with a number of consultation responses in relation to the 23 application, the 22 application, and the 18 application. So and so I followed through the history of that, and again they relate to the planning obligations supplementary guidance, which identifies the site as being within the core intervention zone of Dunfermline, and there's an estimated cost of the 5,332 per dwelling for developments that come forward within that zone. The appellants pointed out that factually it's on the extremity or the extreme eastern periphery of the core zone, on the cusp of the intermediate zone, and the figures for the intermediate zone are less than for the core zone. But in the appellant's view, the interventions for the strategic transport interventions for which contributions are sought are remote from the appeal site and have only a trivial connection with the proposed development. It would therefore not be lawful to require the applicant to enter into such an obligation. And in this regard, the appellant refers to the LZIC case 2018 and the wording of MPF4 policy 18. Does the council wish to respond to the appellant's point of view that came across in the hearing statement? It would be helpful for me.
Yeah, I mean, I think in terms of the reference to the LSIC case, we obviously agree with the outcome of that. I think there's key differences between that and the Dunfermline situation. In the LSIC case, we're looking at a lot larger area where the distances between the interventions and the developments were a lot greater than you've got here. The area covered by that case was in the thousands of square kilometres rather than in the Dunfermline's case, it was in the tens. So the linkage between the impacts and the development are a lot more clearly detailed in this case. This allocated site has formed part and was taken into account in terms of the modelling that was done across Dunfermline to identify what the additional impacts of all those sites across Dunfermline would be. So whilst this is a smaller site, it's still been factored in, and the trips generated from this site have been included to determine the impacts and the required interventions to deal with this site in addition to all the other sites. And I suppose a key point is that we've come up with our figures through our modelling, and I suppose it's really for the applicant to put forward their own transport assessment if they don't agree with our one, to demonstrate why they consider that their development wouldn't have an impact as we've set out that it would.
Okay, Thank you for that. Mr. Fitzpatrick, would you like to come back on any of the points that Mr. Simpson made?
Yes, thank you. So, although the LSIC case did refer to a wider geographical area, the principle is the extent to which there was a direct impact due to traffic associated with the development on these more remote sites. In the framework, I included a table in our hearing submission relating to the interventions, the transport interventions that were being proposed. So you've got the Northern Link Road, you've got the Bothwell Gardens roundabout, you've got Petrevie roundabout, which is now done anyway, and you've got Western Distributor Road. None of these are in any way linked to the development. They could all be, in fact, not considered. They are all remote to the development proposed. And on the basis of the overall principle of triviality established in the LSIC case, there's a clear case to be made on that basis.
Mr. Simpson, I think this is the table you're referring to in your hearing statement, Mr. Fitzpatrick. So that's
yes. Yeah, that's the table.
So does the council consider that those measures is reasonable, that that the proposal is linked to those measures?
I think it's fundamental to the approach taken in terms of, you know, all allocated sites which are going to have an impact contribute. Whilst the impact of this site is clearly going to be smaller than some of the larger sites detailed in it, it wouldn't be reasonable to expect the larger sites to therefore just pay for the impact, you know, or the proportionate impact of the smaller sites. So I wouldn't agree with I wouldn't agree that the interventions that have been set out as being required to deal with the additional traffic are unrelated to this site. The people using this site will benefit from the interventions set out in the obligations guidance. So again, I think the LSIC case it's relevant in terms of the overall principles of it, but I think, you know, the level of modelling, the level of evidence, and the smaller geographical areas allow for a clear understanding and appreciation of the impacts of development on those areas that are required to be where the interventions are required.
Okay, thank you. Mr. Fitzpatrick, you also referred to MPF4 policy 18. Would you like to explain further the implications of that for the transport obligations sought?
Yes, so the point that has been raised there by Derek is a good point. There may be some benefit to vehicles associated with a site. However, policy 18 says that the infrastructure contributions should be related to the direct impact caused by the site. This site is not causing the problems that these transportation interventions are aimed at addressing.
So I'm just trying to find that extract from policy 18 that's where you have MPF4 in front of you. Was it in relation to the where planning obligations are entered into, they have to meet the tests? I think those are the tests from the circular.
It's just under the wording under policy 18. It says the impacts of development proposals on infrastructure should be mitigated. The point we're making is that this development is not causing impacts that these interventions are aimed at addressing.
Would you like to?
Okay, Mr. Simpson, have you?
I don't think MPF4, I don't think it changes what the previous position in terms of there needs to be, a link between the impacts of development and the intervention sought. But I would just stress that the modelling which underpins those interventions included this site. So the impacts of this site were considered as part of that. But as with the education contributions, it's only the greenfield element of the site which would be subject to the contributions, not the brownfield element, which would be exempted as set out in the guidance.
Thank you. Mr. Fitzpatrick, have you anything else you want to comment on in terms of transport interventions? I mean, I have your so you've gone through in some detail in your hearing statement, and I have all of that. But if there's anything else that you want to draw out, I'm happy for you to.
I think we're fine to leave it at that.
The council, anything else you haven't said yet on transport?
No, just if you wanted sight of the background papers behind the modelling, which details the inclusion of the site, we can provide that if necessary.
Okay, I'll give some thought as to whether or not I need that. Obviously, if I do, I'd need to give the appellant the opportunity to comment on it. So that would be another round of procedure. So I'll only ask for it if I think it's essential to my consideration. Okay, if we leave transport, then affordable housing, I don't think this will take us as long. To my understanding is the context for the affordable housing requirement that's listed in policy 1D comes from the Affordable Housing Supplementary Guidance 2018. The appellant, in your hearing statement, you're directing me towards the planning obligations supplementary guidance in relation to affordable housing for back to the greenfield brownfield issue. Is it the appellant's view that I should be looking at the planning obligations supplementary guidance as well as the affordable housing, or is instead of the affordable housing guidance?
Okay, so they're all more or less saying the same thing, so I think it's probably not relevant. I should have perhaps I introduced that as a consideration because clearly the affordable housing policy was going to be front and centre on this, but there is other information supporting the development within the framework.
Certainly, in relation to the certainly figure 1 in the planning obligations process summary doesn't appear to include affordable housing in the development contributions or in the planning obligations guidance. Maybe the council can help me on this. Is affordable housing covered in the planning obligations guidance, or is it just covered in the affordable housing guidance?
It's the affordable housing guidance that applies to the consideration of the level of affordable housing provision required.
And is there anything in the affordable housing guidance that talks about no contributions on?
No, the exemptions are different under the supplementary guidance for affordable housing. It refers to if it's contaminated land posing a significant risk or pollution to water courses. So it's not as the exemptions are not as broad as for the other types of impacts we've been discussing. So there wouldn't be any exemptions on this site for affordable housing, regardless of brownfield or greenfield. It would only be if there was significant contamination on the site or pollution issues posing a risk to health, that there would be scope for exemptions to be applied for affordable housing.
Or less than 10 houses overall.
Unless the thresholds for the
Sorry, could I maybe get you to speak up a wee bit? I'm kind of losing the sound from you, Mr. Simpson. I don't know whether you've moved away further from the microphone.
Sorry, yeah, can you hear me okay? Is that better? Can you hear me?
I could still do with a little bit, certainly was louder, but I don't know whether
Is
was
that
leaning
any
towards the
better?
microphone.
Is that better?
No, that's worse.
I don't know why that. I'm not sure why that might be. Nothing's changed in our setup, so
We can hear you okay still, just to let you know.
okay.
Thank you.
So
You've switched your camera off now from the council's point of view. Yeah.
okay, is
Okay,
that
if you can just try and speak up a little bit, just so I'm not
okay?
missing anything. Okay, Mr. Fitzpatrick, does that change your position? That whether we need to spend more time on this or not? Is the appellant's position that that there should be an exemption for affordable housing contribution?
Yeah, so I'm just trying to find the exemptions under the affordable housing policy. Affordable housing mix. If you'd bear with me for a second.
I think page 10, paragraph 5.5.
Yeah. Exemptions. So yeah, page 10, 5.5, and so I'm looking at 5.5, paragraph H.
Right, so
And it's down to the reuse of long-term vacant or derelict land within a defined settlement. So as far as I'm concerned, that would be an exemption from affordable housing.
does the council have a definition of
Yes,
vacant and derelict land that
those are sites which are identified in our vacant and derelict land audit. So this site is not within that, so it wouldn't fall within the scope of that exemption.
does it say? Is there a definition that tells me that somewhere that's what long-term vacant and derelict land means?
I don't have a copy of the guidance before me, but I can quickly look it up if that's required.
Scroll down, see if there's a glossary. There's a glossary. Yeah, I think if we turn to page 28, Mr. Fitzpatrick, have you got that in front of you? So
Just trying to find it, sorry.
Is that 28 of the affordable housing policy?
yeah, page 28, the affordable housing policy. So it's section 14 glossary. Second one down is brownfield previously developed. We've got, this could include vacant or derelict land, and in brackets, sites on the Scottish Vacant and Derelict Land Register.
So I can do this out. So under the definition of brownfield, it's saying vacant or derelict land, sites on the Scottish Vacant and Derelict Land Register. It would all depend on what how have they classed the site then, and why was this is vacant and land, so why isn't it part of that register? And how has the council defined this land then? Within the local plan, it's identified as a housing opportunity site, brownfield land housing opportunity site. So
Okay, I think we're straying into things that are beyond my remit here. I mean, I think the council's indicated that it's not with it. It's not on the register. I don't think you're saying that it's that it is on the register, and that's probably as far as I can go in relation to. Yes, I've got the views of both sides. I understand the point that the appellant's making, that it should be considered to be vacant and derelict land, and I've got the council's viewpoint on that, and that's certainly helped me understand the context a bit better. Mr. Fitzpatrick, if I consider that the affordable housing contribution is necessary, is there anything that you want to comment on in terms of the details? It goes beyond sort of saying that it's just 25% provision. Information's provided in the condition on the options for delivery. Is there anything in that you want to comment on? Or
I think the affordable housing supplementary guidance goes into great detail on what the level of provision will be and how that is to be provided. So it would all depend on the thresholds of development that we're proposing on the site as to whether it was on-site or off-site provision or a commuted sum payment. So yeah, I think there's clarity on that.
okay. Anything else the council want to say about affordable housing?
No.
Okay. So just generally on before we leave matter 2, is there anything that was raised in the hearing statements for that parties wish to draw to my attention or wish to comment on, or have we covered all of it in our discussions?
Side we've covered everything.
Okay, thanks, Mr. Fitzpatrick. Council, is anything?
No, we're satisfied.
Okay. Are we all doing? Do we want to take a pause now, or will we do matter 3 and then take a break? Any preference? Anybody needing a coffee?
I'm happy to leave it to others to decide on that.
Happy to
Will we
continue.
do matter 3 and then break?
Yeah, that sounds fine.
Okay.
Yes.
That should take us up to 3 o'clock. You just give me a minute till I reorganise my papers. If you could have conditions 1D, 10 and 11 in front of you before this, because I'd like to go through these in some detail. Okay, everybody got that? Now, I can't see either of the two, Mr. Simpson, Mr. Forsyth, can't see either of your faces anymore. That's better. I don't know why the cameras seem to move in and out. Oh, that's nice. Okay. So if we can start with condition 1D. My understanding of the wording is that it requires section 75 to be signed by the council and relevant interested parties prior to the submission of any application for the approval of matters specified in conditions. I don't read it that there's any requirement for contributions to be paid at this stage. The timing of payments would be a matter to be addressed in section 75 agreement. Is that, parties agree with my understanding? I think in your hearing statement, Mr. Fitzpatrick, part of your concern was that contributions would have to be paid before any matters, any application for approval of matters specified in condition were submitted. The council, can you clarify, is that?
Yeah, so yeah, I agree the wording is purely that it be signed. My comments on contributions related to the terms of condition requiring that a payment be made by the first house.
Right.
And so that element, yeah, I apologise for the confusion caused with that.
No, that's okay. That's the real benefit of a hearing, that you can resolve these matters quickly without going back and forward with written submissions. So no, I'm happy that we're all on the same page with that. Now, just point of clarification from the council. So the first sentence of 1D talks about affordable housing, education, strategic transport intervention measures and play provision. Is the play provision an error, or is that still meant to be there?
It's a typographical error. I mean, obviously, it's not something we would or could seek. So, yeah.
Okay, so that's helpful to know that play provision's an error. Yes, when it wasn't included in the bullet points afterwards, I was going back and forward trying to work out what it meant. Okay, no, that's useful. Okay, let's move on to the next ones. We now turn to condition 10. So what condition 10 says that, notwithstanding the terms of condition 1 regarding the timing of the section 75, the signing of section 75 may be delayed until after submission of the first application. Approval matter specified in condition. So that part of condition 1D wouldn't apply anymore. However, in this event, it would have to be signed prior to the commencement of development. So rather than signing the section 75 before the first approval of matter specified conditions application comes in, it would have to be signed. It would have to be signed before development commences. So that would imply that the first application could be approved prior to the signing of the legal agreement. If the wording is that it just has to be signed prior to the commencement of development.
Do you want me to respond to that?
Yeah, I would like to, I suppose that's, especially is that understanding correct, and then perhaps the council, I've got a number of questions that would be helpful for the council to answer. Firstly, the reason for the condition and how it would work in practice.
As explained in our hearing statement, the condition seeks to relax the timescale for signing of the Section 75 agreement, and that was with a view to providing some flexibility for the developer, acknowledging the concern that there was on the part of the applicant, and doing so. Yes, in doing so, it sought to address the applicant's concerns that the obligation-related impacts would not be clear prior to submission of the application for approval of matters specified in conditions. I have to say, and I'm maybe running ahead of ourselves in saying this, I am prepared to concede that condition 10 is probably not necessary, and therefore is not valid, but I may be running ahead in terms of the agenda.
Okay, well, we'll work through it, because I think that it's where it takes us. We may end up in the same place, and obviously get the views of the appellant. But when you say you think it's not necessary, is it you don't think it's necessary to have that relaxation in?
Yes, yes.
So you consider that policy, that condition 1D should stand as it is, that the legal agreement has to come in prior to the submission of the first AMC application?
Yes.
So rather than it not be necessary, you're perhaps, is it that you're saying that that the council's position has changed from the issuing of that?
That on reflection, the Section 75 referred to in condition 1D, it would be worded in general terms to cover all potential development scenarios and obligation-related impacts. So it's probably not necessary to be a sufficient flexibility in the Section 75 to cover all eventualities, and therefore it's probably condition 10 on reflection is probably not necessary. The flexibility would exist within the Section 75. It doesn't need to be provided for by condition 10. In which case, I would concede that condition 10 is not necessary.
Okay, I'll let the appellant come in, but I do have some further questions as well. Mr. Fitzpatrick.
Thank you. So, yeah, I think basically although I'm now hearing that the council would be prepared to admit that condition 10 is not necessary, I don't think the mechanism that exists under condition 1D addresses the issue. There's not sufficient flexibility in there in requiring the signing of a Section 75 agreement prior to submission of an ARC. But I do acknowledge that if they were to change the wording of condition 1D to reflect the intention of condition 10, then that would be a way forward.
Yeah, I think that was something you suggested within your hearing statement, that rather than have an additional condition which caveated condition 1, it would have been open to the council to amend the wording of condition 1D, which was something that that I was going to ask as well. So, Mr. Forsyth, in terms of does your view that condition 10 isn't necessarily require some amendment to condition 1D?
If the terms of condition 10 are required as a freestanding condition 10, then I would argue that they're not required as a variation of condition 1D either. You know, I'll restate that the terms of condition 10
But
as I'm conceding not necessary, then it's not necessary to.
it's not necessary to have that flexibility in terms of timing. I think
it's not necessary to have it anywhere in the permission, because the flexibility is inherent within the, as is usually the case, within the Section 75 agreement.
well, we will come on in the next section to when the other potential ways of addressing the Section 75 agreement. But if condition 10 is removed and condition 1D remains, then the appellant would be required to sign the Section 75 agreement prior to the submission of the first application.
Which is normally the case.
Right. So the council has changed its position in terms of offering that flexibility. Is that?
It's not that we've changed our position in the flexibility, is that the flexibility was already there, and that we've reflected on our position in recent days and concluded that the condition, although it's condition terms, although they were well intended, are not necessary. That the flexibility that we were looking to provide for through the terms of condition 10 are inherent in the negotiation and conclusion of the terms of the Section 75 legal agreement. So one wouldn't want to replicate that flexibility within the planning permission when it's reasonable to expect that the flexibility would be provided for through the Section 75.
Okay, I hear the council's position on it. Mr. Fitzpatrick, do you want to come back on that?
Yes, it's all. I'm not sure that I'm picking this up. So there was an intention to provide flexibility, but now there's not an intention to provide flexibility and to stick with the wording of condition 1D. The point has been made that this would be normal practice to require submission of a Section 75 agreement prior to submission of an application. That's not my understanding. An application would be submitted, and if the council were minded to approve, they would at that stage make a recommendation to committee that they would be minded to approve, subject to a Section 75 agreement. To require the Section 75 agreement up front is at odds with that.
Is there a difference between an application for planning permission in principle and an application for the approval of matters specified in condition?
Sorry, is that addressed to myself?
Yes, please. In the first instance, I suppose, in terms of, because we have a planning permission in principle that's already been submitted and approved, subject to conditions, and the timing relates to the submission of applications for approvals of matters specified in condition. So my understanding scenario that you were talking to would be relate to an application for planning permission in principle. That it would be a minded to grant that you would sign the Section 75 before the decision is issued, but I'm not aware of that being in relation to the submission of approval of matters specified in condition. So, feel free to point me in the right direction if.
So under a planning, strictly speaking, this Section 75 agreement should have been agreed and signed prior to approval of the planning permission in principle. That would be the normal practice. However,
we'll come on to that under item C, because that's something that I'm keen to explore with parties.
If it were to be the case that that omission could now be corrected by condition 1D being amended in its wording to say that prior to approval of an ARC, section 75 would be signed.
Council, you want to come back on any of that before? It might help us to move on to the discussions regarding the other ways of addressing section 75 and then come back to these conditions. It may not neatly follow that we can just tick them off and not go back, but Mr. Forsyth?
Derek is going to speak to that point.
Mr. Simpson?
Yeah, I think I would just kind of, you've already kind of touched on it, but standard practice is that the legal agreement needs to be signed up to release the planning permission in principle. It's not something that can be dealt with at the ARC stage. So I suppose, you know, we would want the comfort that the applicant was agreeable to the heads of terms and that to be signed up to before obviously granting the planning permission in principle. The issues around about contributions and so forth are kind of need to be dealt with prior to the ARC stage.
Okay, that's helpful. Can we look briefly at condition 11 and we'll come back to 10 and 1D I think before we finish this matter, but it'd be helpful to have the council's view on condition 11 and certainly the reasons for that. I mean, my understanding is that it would allow the council to agree in writing that no affordable housing or developer contributions are required, and therefore conditions 1D and 10 in relation to section 75 wouldn't apply. Is my understanding correct of that? And I think it relates to the scale of development, but perhaps the council could explain what circumstances condition 11 would apply.
Yeah, as explained in a hearing statement, condition 11 is simply to recognise that housing development proposed on the site might be so limited, and we heard earlier about brownfield, greenfield and thresholds and what have you. It's to recognise that where no obligations are required until no section 75 agreement would be required, and that condition provides for the developer coming forward to the council and saying, look, I only want to build 9 houses, you know, and develop the site so as not to give rise to any requirement for develop the site in a way that doesn't otherwise give rise to requirements for obligations. That would be a very limited development site. That may not be what the appellant has in mind, but we wanted not to insist that the developer would need to go down a section 75 route. If very limited development of the site meant.
In terms of that less than 10 houses, is that?
Well, that would be the 10
is that
houses.
in the developer obligations framework? Is that the threshold for contributions in that? So if it was a development, that was less than the thresholds in the developer obligations framework, then the council wouldn't be seeking contributions.
Yes, and affordable housing supplementary guidance as well.
Right, is that 10 as well?
Yes, less than 10.
Can I ask first of all the council? I'll come back and get the view of the appellant citizen. How would that approach fit with the LDP allocation for Dun 019, which has an estimated capacity of 35 houses?
I mean, that also need to be a consideration as part of the ARC in terms of the density of development, whether that would be acceptable. But that's just an indicative number of 35, but obviously we'd have to consider the implications through any ARC application if we were going to come forward with a less dense development and what the implications of that would be.
So from the appellant's point of view, is that option something that is the appellant's intentions, or so I don't think there's any, is there any minimum, don't think there's any condition requiring a minimum amount of housing, so Patrick?
Yes, so I'd like to bring Linda in on that. She's had discussions with various developers on the site.
Over many years. Yeah, 35 units on this site is unfeasible completely because of the woodland area and the just general site layout and ground conditions and so forth. So that's not realistic. In terms of it being less than 10 houses, yet we had a degree of interest on that level just because of the contribution issues. The previous conditions were to get more houses. It just wasn't feasible for a developer. We've had many developers come and look and find it unfeasible for that number. So we're probably maximum, I think anybody was talking about was 20 at a push. So there will have to be a reduction on that 35 no matter what, really.
Okay, but you're still looking to keep the well, are you still looking to keep the planning permission in principle open to more than 10 homes?
Yeah, I think so. I mean, we have to try and keep it as feasible as possible to developers, because up to date we've not had any joy getting anything over the line. So
And the figure of 35 is basically set on the council's standard density calculations for the site, which don't always reflect the practicalities of a site. So
okay, that's helpful in terms of understanding the background to 11 and the implications of that. So we can come back to the wording of these. In terms of the tests and the circular, I've got the written comments from you both in relation to these, and I understand the points made. I don't need to go into that in any more detail now, but I'd like to give you the opportunity to respond to each other's hearing statements on this matter if you wish. So the appellant first, is there anything that you want to say in terms of what the council has said about the tests of the circular in relation to conditions 1D? Well, I think Mr. Forsyth has said that he accepts that 10 is no longer necessary, so maybe we don't need to discuss that within this context.
I think basically we've set out in detail test by test regarding the relevance, the compliance with the condition circular, and we're happy to rest on that in terms of our comments on that. The council's comments aren't very detailed on that, so there's not really too much for us to say in that, but there's nothing within the council's comments which would lead us to review our submission.
Okay, it's fine. Say I've got your detailed submission here, and I'm comfortable. I understand where you're coming from on that. The council want to say anything in terms of the appellant submission in relation to the tests?
Yes, I'd like to come back on the appellant's contentions and their hearing statement, if I may.
Yeah, I've got that here. So if you want to just direct me to which parts of it you want to discuss.
In terms of the reference to the necessary test, that the appellant contends that condition 1D, and are we talking specifically about 1D?
1D, 10 and 11 just
Right.
sort of wrapped up within,
Okay.
but you can subdivide them as you required.
Okay, and in terms of condition 1D, and I'll try and keep this brief. The appellant contends that it's not necessary if it's accepted. There's no requirement for obligations. I think that's, yeah,
Yes,
I accept it.
That's an inevitable crossover from the their position on matter one, so I'm
Indeed.
comfortable with that.
Again, if you could bear with me while I go through my notes. In terms of the enforceability of condition 1D, the council considers you have in the condition that was used by Scottish ministers in the Strathmartin Hospital appeal case, sufficient justification for concluding that the approach to Section 75 is enforceable and it otherwise meets the policy and legal tests, and it is intra vires. Whereas the appellant argues that the condition is inherently unenforceable. In terms of the reasonableness of condition 1D, rather, the appellant contends in their hearing statement that compliance with it wouldn't rest with the appellant, but would depend on the council entering into the agreement and completing all the aspects of the process prior to expiry of the timescales for submission of the further application, the approval of matters, application for approval of matters specified in condition, and prior to commencement of works under condition 2. The appellant also contends that the terms are unreasonable and that payment of any obligations would require to be made before any impacts to which the obligations relate actually arise. The council's position is that if we've got an engaged developer who's aware of the council's expectations in terms of obligations, it's reasonable to assume the council would enter into an agreement in a timely manner. The applicant can apply to extend the time limit imposed by condition 2 if unexpected delays arise. The agreement would be worded to cover all potential development scenarios and obligation-related impacts. And I think I'm right in saying the appellant's already conceded that they were mistaken in assuming that there was a condition requirement for the council to seek payment in advance of development impacts through Section 75. That's certainly not a requirement of any of the conditions. In relation to condition 11, if you could bear with me just a moment. Yes, the appellant intends there is I think it refers to it as a contradiction between condition 11 and condition 1D, and that's not within the appellant's control to achieve compliance with condition 11, making condition 11 unenforceable, but I don't accept that either. I think you have to read condition 11 and condition 1D together, and read together, there's a legal requirement is required unless we've agreed it's not required. And the agreement would cover, as I say, different development scenarios and obligation-related impacts. If obligations are required and development proceeds without any legal agreement that's required having been submitted through application, submitted through approval of matters specified in conditions, then there would be a breach of control that could be enforced. again, in relation to condition 11, I don't agree with the appellant's contention that there is any imprecision in this condition. However, I guess you might want to vary it to reflect circumstances on which obligations would be required. If you think that would be helpful and appropriate to do so, but I'm not sure it's strictly necessary. Again, in regards to condition 11, the appellant argues that it's unreasonable in terms of the payment trigger. But I think earlier the appellant has conceded on that point. But yes, in terms of meeting the policy tests across 1D and 11, I've already conceded condition 10 is we consider condition 10 as on reflection unnecessary. But in terms of the policy tests as they relate to 1D and 11, that's all I wish to say.
Thank you, Mr. Forsyth. Mr. Fitzpatrick, do you want to come back on anything that Mr. Forsyth said there?
Yeah, so in relation to the Strathmartin Hospital case, I've clearly demonstrated under previous submissions that does not apply here, because in that case, although the Scottish ministers agreed that the requirement for a Section 75 could be included within the condition, the point being made by the council was that this had been forced on the developer by the Scottish Government, and that's not the case. The developer at Strathmartin Hospital had agreed to that wording of a condition in advance. So under the terms of the conditions circular, it's ultra vires to include a requirement for a Section 75 agreement in a condition. Now, in relation to summing up all the other comments relating to the feasibility of pursuing the conditions, basically the condition circular states that it must be within the applicant's ability to comply with the condition, and that's quite clearly not the case if we are dependent on the council agreeing a Section 75 agreement. So we cannot. So that contradicts the condition circular as well. Mention was made on enforceability as well. Under the terms of condition 1D, there's no remedy to a breach of the condition, therefore it's unenforceable. By the time, if we were to submit the ARC without entering into the Section 75 agreement, we will at that point have breached the terms of that condition. And there's no remedy to that. What enforcement is the council going to take upon us if we were to go down that line and submit the application? There's no remedy, therefore it's unenforceable. And in relation to other aspects, any requirement to force an agreement via third party quite clearly does not sit well with the condition circular.
Okay, thanks for that. I recognise a number of those points from your earlier submissions. So and I think again the council had already commented on some of those as well. So but is there anything else you want to come back on, Mr. Forsyth? And then I think we'll take a wee break.
Yeah, it was just this is probably quite timely then. The condition approach is through Section 75 is something that Mr. Fitzpatrick has agreed to previously. The requirement to sign the Section 75 before approval of matters specified in condition dates back to the original 2008 application. We've had the same agent submitting all the subsequent applications for housing on this site in an email dated 18th December 2018, which I'm happy to lodge if required.
It's okay. Mr. President, I think I'll maybe stop you there because I need to just address the matters before me in terms of the evidence.
Well,
so I'm aware that the council has made the point about the fact that this approach has been used in subsequent applications.
Well, the point
so I'm aware
to make with respect is that Mr. Fitzpatrick has asked for this approach to be used. And if you'll allow me to continue, he says in an email to the then case officer in dealing with 18-02023 PP, dated 18th December 28.
That information isn't before me, so I can't take it into account.
Well,
if I think I need it, I can ask for it. But I'm saying that I don't think I need it. So it would have been open to the council to submit that before now.
Yeah, if you need evidence that that Mr. Fitzpatrick had promoted the approach, then we're happy to lodge that.
Okay, but thank you for explaining that. But we are where we are in terms of the appeal is seeking a different approach, and that's what I have to determine. So while there is ultimately a planning history, it is open to an applicant to pursue a appeal on this matter, and that's what for me. Let's take a break. I think it may take us some time to go through matters.
Would I be able to say one thing on that before we do take a break? Although I've been the agent right through, I've not been working for the same applicant right through, so I'm under different instructions now, which makes a fundamental difference.
And I think you've made that clear in your statements before, so that's not news to me either. I think you've stated that. Okay, let's take a break. Oh, bang on 3 o'clock. Is 15 minutes sufficient? We come back at 3:15, and we'll start on. We're exploring the implications of a different approach to the Section 75 as part of the condition. So go and grab a coffee, freshen up, and we'll see everybody back at 3:15.
Hello.
Hi. Are we first back? That's good. It's amazing where 2 hours go in a blur.
Exhausting.
I think people find it is more tiring doing these things virtually than in person, which is why you do need to have regular breaks. It's
Yeah.
been useful for I mean, it's obviously something that started during lockdown, and you know, it's an efficient way of doing particular types of procedure if there's not a lot of you know, third parties interested. You know, you're not getting local people wanting to involved. I'm sure we don't have anybody watching us on the webcast.
We might have, who knows? Say
Who
hi to the
knows?
world. I said to Joe not to swear because we might be on live television.
We'll be there forever. Are we good to go? Are we all back? I can't.
Yeah.
Yeah.
Yes.
There we go. I'm only seeing
Flint,
part
Flint.
of you again, so you'll have to huddle closer. Thank you very much. Okay, hope you're suitably refreshed. So we were going to start on matter 3.c, which in response to the procedure notice, both parties indicated that a potential alternative to condition 1D would be to require a legal agreement to be signed prior to the granting of planning permission. And I think they understand that that's the normal practice in Fife rather than requiring the signing of a Section 75 as a condition of a permission. So if I consider that developer contributions and/or affordable housing are required, what are the views of parties on me using this approach? So this would involve me issuing an intentions notice, which would allow time for the Section 75 to be entered into prior to the issuing of a decision. And conditions 1D, 10 and 11 would then be removed. So appellant, turning to the appellant first, is this something that what's the views of the appellant on that as an option?
Yeah, so we've made it clear that in the hearing submission that, you know, we're not against the Section 75 agreement. The main issue is the extent of it on the greenfield brownfield element, and I'll not go there again.
So I'd have a few to caveat it on that basis.
Yeah, so yeah, I mean, subject to that approach, I would think that that's something which could be considered acceptable, and that it would give us a little bit more clarity. So I'm presuming that you're meaning before you determine the outcome of the appeal.
Yes.
There would be this requirement.
Yes. What I would do would be set it out as almost as that I am minded to grant permission subject to a Section 75 agreement covering the matters that I think need to be addressed. So that would be based on those matters in condition 1D that I consider require to be addressed in order to mitigate the impact of this development. And that's the normal practice for appeals where contributions are required, and then that allows parties to come back on any matters. But generally, the time is for the parties to get together then to prepare the Section 75 agreement. And I suppose part of one of the benefits of that is it allows the sort of detailed matters and nuances to be thrashed out between parties in a way that it's probably you're not able to do through a condition.
Yes.
The council have a view on that as a way forward in this case?
I think we're generally fine with the principle of issuing an intentions notice to grant planning permission subject to prior conclusion of the legal agreement. I think the issue for us at the time of submitting our hearing statement was if you were to issue an intentions notice, as you say, to grant planning permission, perhaps with condition 1D being omitted or varied in some way, and subject to prior conclusion of planning obligations with the planning authority. What would that say or appear to say about the enforceability of the same condition 1D on the previous planning permission in principle, and what would it say about the ability to implement that previous valid planning permission? However, in terms of the ability to implement that previous permission, if we received an application for approval of matter specified in condition, which wasn't accompanied with a signed Section 75 legal agreement, we wouldn't entertain it anyway. So, should you be minded to go down the route you're describing, I think you're comfortable with that.
Okay, I mean, it's not my role to comment on the previous permissions. What I was keen to do this is to try and see whether there's an alternative way which would find an alternative way forward that would unlock what is essentially a local development plan housing allocation. You know, that has got stuck, and this is potentially a way forward that obviously hasn't been addressed before on this particular site. So it's not for me to comment on the previous conditions and the previous applications. I'm very much aware of the permission. I'm to address the permission for me, which is the 23 one, and the matters raised by this appeal. So the appellant was seeking the removal of conditions 1D, and we'll come on to 3, and by default conditions 10 and 11 got tied up in that, although they aren't specifically mentioned in the appeal. So that's the intention of that question, is to explore whether it's a potential way forward should I consider that developer contributions and affordable housing are required.
Yeah, we've no objections in that to going down the route you described.
Anything else the appellant wants to say on that matter?
Yes, so I mean, the whole point in this has been the uncertainty, because there's never been that element of agreeing what's green and what's brownfield land. And given that you're going to be making a determination on that, we're comfortable with it. However, I would like to discuss a potential other option. Would another option be to review that and have the Section 75 agreement agreed prior to approval of any ARC? So this appeal would be determined, we would get clarity on the greenfield, brownfield element, and then on that basis, we could then proceed to a Section 75 agreement being agreed prior to approval of the ARC. Now, the benefit from the appellant's point of view is that we're not developers, and we won't be developing the site. It's really something which we want to make progress with the marketing of the site, and I see that as a potential way forward to doing so.
Okay, let's explore that to see what it means. So back to the appeal before me relates to the wording was seeking the removal of condition 1D, what changes would the appellant seek in relation to the wording of that policy then? Nothing? Because that just requires the signing of the section 75.
No, we would still ask for removal of 1D, but it would be on the basis that there's an agreement that there'd be no approval of the final ARC without that section 75 being signed.
So it would be, in effect, it would be changing 1D to the agreement being required before the approval is before approval is given rather than before approval is submitted. So does it relate to the timing of the section 75? Sorry if I'm not getting.
No, it would just be to remove condition 1D altogether, because it's then within the council's power not to progress to final determination of the ARC until the section 75 is agreed.
There'd be no mention of a section 75 if condition 1D is removed and it's not amended to grant subject to section 75, then there would be no mechanism for the council to require section 70 to require contributions, because it would neither be in a condition nor in a legal agreement, and that the decision would be issued.
Yeah, I know it's an ARC, and strictly speaking, it's not planning permission, and as such, it's just purely purifying the conditions. But if there were to be an agreement that those conditions couldn't be finally purified until there was a section 75 agreement approved, I can see the difficulties with that. That's why we're happy to run with the appeal being assisted until such time as the section 75 is agreed. So I really don't want to muddy the waters on that. I'm just putting it in as a suggestion.
Does the council have a view on that while I think through the implications further?
Yeah, I mean, my understanding is that the requirement for the contributions needs to be set at the planning permission in principle stage. As Joe said, that the ARC application is not a planning application, and if the planning permission in principle didn't make mention of or a requirement for contributions through a mechanism, then we would have no recourse to require that at the ARC stage.
Okay. You want to say anything further, Mr. Fitzpatrick?
We would accept a condition saying that prior to approval of the ARC, the section 75 had to be agreed.
So that would be an amendment of 1D, because it would be necessary for the council needs to set. It wouldn't be helpful to anybody if the council didn't set out what the contributions were, subject to obviously to my views on them. So I mean, I suppose what I consider the potential you're suggesting is an amended wording to 1D to almost incorporate condition 10. So it basically knocks back the time scale of when the section 75 is signed, but the details would still be in the condition.
As a compromise position, we would accept that.
Is that in what order would the appellant prefer? Either the section 75 signed prior to the issuing or an amendment of 1D? Just trying to, I'll give the council the opportunity to comment as well. I'm just trying to understand where people's points of view are on this.
If we were to amend condition 1D so that the section 75 would have to be signed prior to the ARC being approved, then that would be acceptable.
Would you prefer that rather than a minded to grant section 75?
Probably yes, because we'd then have clarity on the greenfield, brownfield element, and and that's the major sticking point on marketing this site. As you say, it's an LDP site which has been held up for years and years because of this uncertainty.
Okay, well, I'll weigh up those options, understanding that the one of the drivers is the appellant seeking clarity on the greenfield brownfield. Council, I mean, that again, what that seems to be doing is taking your condition 10, which you indicate that you no longer consider necessary, and almost making it slightly less flexible, because it doesn't relate to the commencement of development, that would relate to the approval of an AMC. So is the council's preference to go down that route or to go down the minded to grant?
Minded to grant with the legal agreement. I think it's not lost on us that, you know, the approach being postulated there does potentially undermine some of the appellant's arguments with regards to the condition in the first place. But you know, I think part of the rationale for the legal agreement being signed up to at the planning permission in principle stage is just so all parties are in agreement and have an understanding as to what's required on that site going forward. I think, you know, the potential is thereafter to get into difficulties at the ARC stage. And I think clarity regarding the greenfield, brownfield would likely come through your decision on this case, with respect to how that applies to any legal agreement.
Yeah. Okay. Well, I think I understand the views. I think I have enough to get a way forward on that. Thank you. Okay, so anything else under matter 3 that anybody wants to bring up? So that's anything else in relation to conditions 1D, 10 and 11 before we move on to condition 3?
No.
Likewise, we're happy to rest on what's in the hearing statement.
Great, thank you. Okay, so condition 3. So this is the one that I was hoping to have a transport officer from the council for, but I'm hoping that you're able to answer on their behalf.
I hope so too. As you can imagine, there was they weren't jumping up and down to volunteer, but I have had detailed discussions with my transportation colleagues, so hopefully we can.
Okay, I think it's important to understand the reasoning behind this condition, and in terms of the appellant has suggested some alternative measures that perhaps transport officers may have a different view on than planning. But if they didn't take up your invitation to attend, then they'll have to rely on your judgment and take it from there. Okay, so what would be helpful if you get out, this is the plan that the appellant sent as part of the hearing statement. It would be useful to have that. And obviously the wording of condition 3, which is in the okay, so my reading is that condition 3 kind of forms there's two parts to it. So the first part appears to relate to the timing of the timing and standard of works constructed on or adjacent to public roads in general. It's very much just a statement in relation to making sure that these are undertaken prior to the occupation of the first dwelling, and we'll discuss the other clause, and that they'll be constructed in accordance with the guidelines and the Scots Roads Development Guide. And then the second part requires Masterton Road to be upgraded between the site frontage and its southern junction with Skylark Road, including the provision of curbs, minimum carriage width of 5.5 metres, provision of a 2 metre wide footway on the west side of the road, and suitable carriageway patching, resurfacing, etc. So if we look at the additional clause that was put in for this permission compared to the 2022 one says, and unless otherwise agreed in advance in writing. Now, I asked the question whether that should have been or otherwise agreed in advance in writing. I think the appellants thought it should. The council said possibly, but it wouldn't make any difference. Can you help me? I can't understand it if it says if the word and is to remain. So can the council help me out in terms of that first, in terms of the wording in bold?
I would accept that it's that or would be the correct word to be there. And in terms of that part of the sentence being added in there, again, I think it was designed to provide a bit of flexibility, but it probably didn't need to be there. But I think what it does acknowledge the fact is that it doesn't preclude a section 42 coming in to change the terms of the condition, but it probably didn't need to be said. So my reading of it was that it provides flexibility in terms of timescales. So the works need to be done prior to the occupation of the first dwelling house, or unless agreed in advance. So it would be open to the council to agree that some of these works could take place later in the development. Yeah, I would accept that.
Well, the responses that I got to the procedure notice, the appellant was of the view that that extra clause opened up scope for alternative measures in relation to Masterton Road, and the council suggested that it provided for possible development of a site so limited that the specified upgrade to Masterton Road wasn't justified. And I struggled with both of those because the clause relates to that first sentence, which is about general, not Masterton Road. So if it was the council's intention to provide flexibility in relation to Masterton Road, then I suppose is the clause in the wrong place?
No, I think it was to do with the timing of the provision of the required works in terms of that's with before the semicolon there. So it wouldn't be proper in my view to allow or to have that degree of uncertainty with regards to what's required to be done. The proper recourse for that would be a section 42, because that would be a material change to the requirements of the consent.
Okay. Mr. Fitzpatrick, do you want to come back on that? Because I have to say it's a confusing condition to whenever you break it down into those details to understand what's been sought. But that's helpful, Mr. Simpson, in terms of clarifying the council's position. Mr. Fitzpatrick, do you have a view on that?
Yes. So the reason I'd put in that this opens up scope for an alternative arrangement to be entered into is that although that clause is associated with the first sentence, which is the general works, the second part of the condition does go on to specify what those works are, and our main concern is this 2 metre wide footpath that has been required, and under the current wording, that clause, if it said or instead of and, would then open up scope for us to put forward alternative means of achieving more adequate links to the
Do you think
development.
that the initial that clause doesn't just relate to the timescales? It's not just
No.
or prior to the occupation.
No, I'm seeing that as offering up scope to examine the details of delivery of the second aspect of it, the works, as it refers to, all works.
I mean, through this appeal, we will be looking at the details of the second part anyway, because
Okay.
the appeal is in
Yeah.
relation to that. So a different interpretation of that first sentence doesn't prevent us looking at whether or not that the second part of the sentence, meets the test of the circular, and we'll explore what it's trying to achieve. So I say it's helpful to get the views of parties on that first bit, but I think the nub of where the appellant comes from, I think, relates to the second part, and we will move on to that.
Yeah, that's totally happy with that. Yeah.
Okay, but it's helpful for me to understand. Right. Okay, so it would be helpful if the council could explain in detail what is required by the second part of it, in terms of what that'll mean for works on that part of the road between the site and the junction, in terms of the provision of curbs. Is that on both sides of the road? 2 metre wide footway, is it envisaged that it'll demolish the requirement will be to demolish the stone wall? I don't know if you've been out to the site, Mr. Simpson, but we measured it on the site. So basically, the along the road is 5.5 metres wide. When we measured it at the site, I think there had been some vegetation that had made it narrower, but that's now been cleared back. So there's sufficient width of a road, but there wouldn't be sufficient width to put a 2 metre wide footway on the west side. On the road side, it would either have to be on the other side of the stone wall, or would require the demolition of the stone wall. I was just trying to understand, and that's why I say it may be that the roads officers had a view on this, or they may not have considered it.
Just to clarify, when you reference the stone wall, is that the stone wall within the site? The front?
No, it's beyond the site. So if you look at so it's from the site down south of the site along the Masterton Road. So the requirement of the condition is to ensure that's at 5.5 metres wide, and to put in a 2 metre footway along the western side of the road, and there's a stone wall along that part of the site.
I think transportation colleagues probably wouldn't be too concerned about the loss of a wall, and it would have been for the planning officer probably to consider the implications of what transportation we're asking for in terms of that. So being candid, I think there's clearly a technical solution that could be done, but it might result in the loss of the wall. But I don't know if it might help circling back to that once we've had discussions about the requirement for that footpath, possibly.
Yeah, well, that would be helpful to know, because what I was was in asking for the information in terms of where the site sits in relation to the facilities that occupiers of houses. I was trying to understand how many would travel in that direction.
Yes.
And that's been helpful information provided by the appellant, and I think the council are happy to support that information.
Yeah.
So yes, if you could comment on that would be really useful.
I mean, I can maybe just start by giving a bit of, because I'm conscious that there was a similar condition, but excluding the 2 metre wide footway requirement was on the 2008 and 2015 applications. So that included the requirement for the 5.5 metre wide in the curbing, but it didn't include the requirement for the footway provision to the south. That came about due to there's a path, an adopted path to the south, which was put in, which is lit, was put in before the 2015 application was determined, and that was
whereabouts is that footpath?
It's the one you can see at where the Masterton Road's kind of splits off to the south of the other allocated south to the south of the appellant site along there.
That junction there.
Yeah, so the path that extends
so there was
westwards.
a path
so
along there.
That wasn't sort of to an adoptable standard and letting things prior to that. So I think the rationale for transportation, including that additional requirement, was reflective of the fact that that path was in place at the time that the application was determined then, and it wasn't there before. So I think part of the rationale was that there's an adopted footpath link there, and therefore which affords.
Can I just clarify that footpath links through to the business park? Is that understanding that if you join that and head
South
west
Castle
direction.
Drive, is it South Castle Drive? Yeah. So that I think that was what where the sort of rationale for that approach came from. So I think that's the reason why
I think the wording of the condition is that the footpath should go as far as Skylark Road, so it would go beyond that footpath.
Yeah, I think that's correct, and I think and obviously in terms of designing streets and connectivity and so forth, then obviously ideally you'll have those links there. But we do accept that matters are complicated by the fact that there's another site to the south there, which you would expect to the burden not to fully land on perhaps the applicant's position, but at the same time, how do we, what's equitable in terms of dividing up the responsibility for delivering that if you deem that it's required. I would also say that I found some of the justification put forward by the appellant quite compelling in terms of accepting that a lot of the points you would kind of walk to would more logically be to the north of the site. So I do accept that. I do accept that argument. However, at the same time, I think the intentions from transportation in terms of getting the roads improvements are and were well intended, but at the same time, up until this point, there really hadn't been a more detailed assessment of potentially the pedestrian flows from the site, which has come through from the appellant's case, which I accept does have weight in terms of considering that condition.
So is it still the council's position that condition as drafted is necessary and reasonable?
I think it's maybe less reasonable in light of the appellant's submissions with regard to this application. I think in these instances, there's always a difficulty in terms of infrastructure beyond the kind of immediate sort of frontages or bounds of the site, and it's a judgment call. But I do accept that is a long stretch of road and a big infrastructure burden on the applicants. So I think from a transportation perspective, I think completely reasonable that they asked for that. But on reflection, I think in terms of the planning authority's position on that, there maybe could have been more discussion with the applicant at that stage. But obviously that was put on and wasn't challenged, and we are where we are. But we do accept some of the points made by the appellant with regards to that. So okay,
so is it worth having the discussion? Well, we will anyway, but I think it's worth having that discussion where the appellant has suggested some alternatives, which may be other ways that the access can be for pedestrians in a southerly direction can be provided, potentially not to the all bells and whistles of the that's what's in the condition, that may also be more beneficial in terms of environmental impact in relation to the roads. And I think there was a representation into the application from a resident, you know, concerned that that perhaps the urbanizing impact of the development. So this may be an opportunity for a more appropriate solution for the nature of that road in relation to the facilities that the people are going to address. So is that the council happy to proceed on that basis if we look at what is perhaps a reasonable alternative?
Yeah, and I suppose that's part of the challenge in terms of, is there a reasonable alternative? And I think, you know, we would have some concerns about, you know, safety and, you know, the lack of passive surveillance. We accept that, you know, there's, in terms of the existing requirement for the 2 metre wide footway, there's not sort of, you know, surveillance in terms of property over that at this time, but should the other side come forward, that would be less of an issue, plus there's lighting and so forth. But, you know, the link proposed to the south, I think, obviously there needs to be that needs to be weighed in the context of, is it really a safe route that people are going to want to use if it's not letting up to a standard which is more than just a sort of rural footpath. So I think if the conclusion was that the footpath, 2 metre wide footpath to the south as specified, wasn't reasonable or justified, if that was the conclusion, then I've got other comments to make about condition 5, which might tie in with that. But I guess it would need more consideration about the pros and cons of a link which maybe wasn't safe or appealing versus, you know, having nothing.
Okay, let's maybe break it down. We've maybe gone Mr. Fitzpatrick, is there anything you want to say at this point before we go on and look at potential alternatives? I mean, I think your statement is clear on this. I suppose one thing that hasn't come up so far is that the appellant said that it wouldn't be possible to run a path in the area to the southwest of Masterton Road because there's a steep drop away from the road on that side. Mr. Fitzpatrick, can you show me on the map where the drop is? That the part of the road beyond the pathway, or is it in?
Yes.
You need to bring your map further into the screen. Sorry, we're not seeing it. There you go.
Right.
Thank you.
Yeah. Is it beyond?
Yeah.
The
beyond
bit
there.
between the path and Skylock Road where there's the drop.
Yes.
Yeah.
So
Right, we didn't walk that far
Can I-
down on the site visits.
Can I just explain as well the path that's been spoken about to the south?
Yeah, the green dashed line.
No,
that you're
sorry,
suggesting.
the path line to the south that we were
Derek
discussing
was a link to.
the link road, as it were, between Masterton Road and the Carnegie campus along the
Yes.
bottom. Yeah,
Yeah.
that was a road, an actual vehicles road, until they stopped it up. It's not. It's a substantial footpath. It always has been. It just is there. And what the issue we have with the whole length of the thing, the whole length of Masterton Road out to Skylark, is that, well, firstly, no one would go that far because there's nowhere to go beyond that. But also, it is the fall off down the hill there, where you can't have it on that side. You'd have to have it on the other side if you had anything at all. And it's just that it's the linkage to the south is you could put it anywhere, it doesn't matter really, but to take down the wall adjacent to the road seems illogical because we don't need to, and it doesn't fit with the whole section of road, really. It doesn't, it sort of sticks out. It would be like going like that rather than going like that.
in addition to that, could I add something else? So
Yep.
even the section of footpath linking down to that route, which has always existed, the road that links into Carnegie campus, that we would question the requirement for that, because that is linking, if the issue is security and passive surveillance, that road along the bottom there lacks that degree of security as well.
People park up to dump rubbish and take drugs and all sorts on that part. So it's not.
People
Is that
will be avoiding
is that
that.
the one that's lit? Is that what the council has said that
It
there is
is
lighting, but
it's technically lit. It's largely more lit by the buildings to the south, actually. But there are 2 street lamps on that stretch. But they're the council has not cut back the bushes to allow the street lamps to be effective, and in fact one of them's been out probably for the last year. So I don't think it's, people walk up there with their dogs in the dark with head torches. It's not as you'd think a well lit street path. And
the issue with the rural nature of the road, of the alternative provision that we're proposing, is that the burden that would then enable, that would be a temporary alternative link pending development of the site to the south.
The north-south green.
Yes.
So you suggest.
And to be perfectly honest, there's a more secure route, more streetlit, more surveyed route to the north. Just going out onto Skylark Road and then that's the route we've shown, which is by far the best route.
And living here, that's the only route I would use at night, because the rest are dark, and people do use their other roads in the dark, but you wouldn't want to. You tend to go north.
Mm-hmm.
Can I ask the council for their views on the need or reasonableness of the two options? So one option has been suggested is the kind of the east-west link along front of the properties. This name I can't read on that on the map, which would provide a link between the site, Masterton Road and Skylark Road, and then the north-south link down to the footpath to the business park. Are those considered to be reasonable alternatives? Are they necessary in the council's view?
In terms of whether they're kind of reasonable, I think that the east-west one onto Skylark Road, I'm speaking with transportation colleagues, they wouldn't be happy with that as an alternative, because of I don't think there's a safe crossing point on that road where that path exits there. So they wouldn't support that.
Okay, that's helpful to know.
Yeah, there's no sort of fundamental kind of roads.
Sorry, if we've still got our thing on. Sorry, I would just say about the crossing point there, just that.
Sorry, Ms. Timpson, can I just let me hear from the council first, and then I'll give you an opportunity to comment. Thank you.
So the transportation wouldn't be supportive of that as an alternative. In terms of the one to the south, from a transportation perspective, I think there's no sort of road safety issues. It's more of a kind of pedestrian safety issue, and I think if that was to be an option going forward, I don't think they would be supportive of the kind of rural type path that was being proposed. They would want it to be more of a traditional formal footpath connection to be put in there. And in terms of the reasonableness, I mean, I think going back partly to what transportation colleagues were saying with regards to the requirement for the 2 metre wide footway to the south was partly in relation to Inverkeithing train station. Again, I don't know that area particularly well, but I think part of the rationale was to provide pedestrian access should people want to walk to the station to the south, to the southeast there. But whether or not that in and of itself, I mean, I think what was being discussed there in terms of a footpath link to where Skylark Road meets the footpath which is currently lit to the south, Masterton Road, sorry, where it meets the footpath to the south. I think you know, that would be, you know, if that was to be a compromise position and not extending fully onto the Skylark Road, then that might be something that would be. I suppose, I mean, the issue again is that, you know, if that other development comes forward and the requirement of that development is that footpath, some traffic from this development will use that. So, but maybe not as much, and maybe the, you know, in that assessment it's considered it's not necessary. But I think that case would have to be made.
Thank you. Ms Tenson, do you want to come in now on some of those points?
Yeah, just with the road that is going east to west, the proposed pathway east to west. When you they say there's no safe crossing point, you wouldn't need to cross, because there's a 2 metre wide grass verge that's adopted by the council that goes all the way along to the crossing point on that side of the road. I walk it all the time. So it would just be a question of potentially surfacing that side of it. That's all, if they had to. The other issue was the area to the south going out to reach Inverkeithing Station. It's 2.5 miles away, and there is no footpath down that road. So it's very unlikely people would walk to Inverkeithing Station. They would walk, if anywhere, to Rosyth Station, which is considerably closer, and I do often myself. And
how far away is Rosyth Station, Miss Tenson?
It takes me about 17 minutes to walk there, so I'm quite slow. But that's coming out the north and down through to that roundabout in Carnegie Campus, and then through the back past Petrevie Castle, and that takes you down to the junction with the big roundabout at Petrevie.
So it's about a mile.
It's about a mile. Yeah, it's about a mile, because I was training for walking, and it is about a mile. It's much closer. Inverkeithing Station, we were kids, we used to take our bikes down and nearly kill ourselves. It is not a safe route to walk on. The public footpath on Skylark finishes at the junction of Masterton Road. It does not go any further. You can't go on a footpath beyond the bottom at Skylark.
Right, so south of the junction.
Yeah, there's no
Skylark,
footpath.
there's no footpath.
No. And in fact, Skylark's footpaths are strange, because it's all lit up and it's a wonderful footpath. It doesn't go anywhere.
Okay. Can I ask the council, the appellants indicated that it would support the requirement to reintroduce white lining to denote the carriageway edge on Masterton Road. Does the council have a view on that?
Yeah, I think, you know, if the decision of the appeal was that a footpath link wasn't required down that extent, then we would have no issue with the white lining rather than curbing.
That's helpful too. Okay, and then if I was trying to think through the implications of if the 2 metre footway was required and it was routed through the field to the west rather than removing the existing boundary wall. I think you mentioned about overlooking and that being an issue in terms of safety. But would that have implications for the development of that site? So obviously that would take it through the site. Is it?
If that's for us, yeah. I mean, if you put the footpath inside the wall, we would be presumably at some point breaching that wall to take an entrance into housing in that lower part of the field, because the top part is way too steep anyway for that housing. And so, yeah, there would be a degree of doing and undoing as well.
Just thinking through that on the map, but what I was trying to envisage would be where a footpath would come from, because
Yeah,
the,
so the reason we put in the one down the west side is that it comes, you know, through the back of that wood that we visited,
yeah,
and goes down the hill adjacent to the new planting of the woodland we've got in there, and it would just take you straight down to the corner of the field, which takes you straight into the campus.
okay, that's the green dashed line. I'm still on the one
Sorry.
sort of the potential for a footpath immediately to the west of the stone wall.
Okay.
How would a footpath there link to the site itself? Because what I was trying to envisage was the part of the site immediately to the north of the farmhouse. I couldn't see how there'd be an opportunity to put a footpath along that without going into the garden of the farmhouse.
It would actually be the garden of the cottage, and we'd have to take down those massive retaining walls in there, which is again why we thought, well, let's go around the other way. We don't have to take down massive retaining walls and encroach on the garden of the cottages.
Will the council have a view on that? You see, the corner of the red of the site. So to get from there down to there's a couple of cottages there that's with their garden ground. And I couldn't envisage how you would get a 2 metre wide footway there to link into the one that'll then either knock down the wall. But I'm not sure again whether the details of that just hadn't been thought through when they.
Would it be appropriate to open up Google Street View to maybe just, I mean, I don't have an in-depth knowledge as obviously as appellant, but just to have it on screen so we're all clear as to what we're talking to. I could share that if that was.
Yeah, that would be helpful. That
I seem to have the share one disabled unless
right.
Or someone else could.
David might be able to. We'll see whether David's listening or not. David, are you able to let the council share their screen? He's there.
Our share's disabled as well. It must be part of the issue. I could explain it probably.
Well,
maybe
you've got it now.
different.
I've got it now. I could try and I'll try and share it.
Thanks, David.
Sorry, just bear with me.
Right.
Can everyone see that?
We can, yes.
I was having a look at I was looking at it in reference to the discussions in terms of the east-west and potential link to the east of the site. I was just trying to get an understanding of what the appellant was saying with regards to the feasibility of that. But I can move away from that and go to the
yeah, if you could go onto Masterton Road, that would be helpful.
Yeah.
There we are. Well spotted.
So to this section here that was being referenced in terms of the implications of the footpath along that stretch.
Yes, that's what I was trying to think how you get from the site to along the.
Yeah, that is the sort of pinch point, which would be a major job to try and put a footpath anywhere there. You would have to take down those massive retaining walls.
Is it affecting other people's land?
If it was on this side of the road, yeah.
I think from a transportation perspective, that there probably is a technical solution that would deliver that, but I suppose from my perspective, I don't know the full implications of that, so I wouldn't be able to weigh up, I guess.
Okay,
It's
but
extremely
it's-
costly from what we looked into it, and that's why we came up with the other alternatives to avoid that.
If we sort of head south a little bit, I mean, one of the things that I wondered if, in terms of if there was a requirement for a path along this, whether it could link up through to the site from the access road that sort of wraps around the southern part of the site, takes you through. I suppose that, yeah. So would it be possible to come from the site through there, through the gate and down?
It would be straight through our driveway.
Okay.
You know,
No, that's why I
so-
wanted to ask the question. Because things that look potential on a map, it's useful to discuss in terms of.
yeah,
okay,
right
so
past our
that's-
back door.
Okay, Mr. Simpson, have you got a?
No, I suppose it just raises the question, if there's not safe pedestrian links, whether or not that, that in and of itself is a material issue that outweighs the benefits of the site coming forward. So I wouldn't have anything else to add. I do have something to add about condition 5, which I know is not specifically within the scope, but I just thought it might be something that the applicants would be.
Okay, can we come back to that once we finish that? Can we turn the mapping round and head south down Masterton Road? Yeah, so really, this is the stone wall on the western side, and I think part of that foliage has probably been, vegetation has probably been cleared back now in terms of the.
Yes, it has. That was the summer, and we had it cut back because it was becoming, ridiculous, and the council didn't do anything about it. So we had it cut back.
That was the bit that I measured on the site visit from the wall across, which was the 5.5 meters. So yeah, it's I think in order to get a 2 meter wide footway down here, it's either going to have to be that side of the stone wall, or it's going to have to remove the stone wall. I think that's the reality of what that condition would mean.
Yeah.
Okay, can we keep heading south down to the junction with the footpath we were talking about, just so we're. Yeah, so that's the bit that was previously a road that's now a footpath with some lights that takes you through to the business park.
Yeah, and then that's it.
Yeah, and then if we go south again, just the section beyond that on Masterton Road. I think are we heading up or? Yeah, so this is the bit. This is the bit where there's the drop that the appellant spoke about, that it'd be difficult to. Okay, and that's if we keep going, we get to the junction.
Beyond
so
the wall, drops
the condition at the minute requires all of that to be footpaths as well, right up to the junction with Skylark Road. Okay, that's been very helpful, Mr. Simpson, in terms of that. Let me just see what else I had to cover, and then we'll have a wee. Okay, do you want to raise the matter in relation to section 5 then, if it's related to, or into condition 5 if it relates to our deliberations on condition 3?
Yeah, I suppose it kind of raises similar issues. I'm conscious that there's a nice traditional stone wall which bounds the appellant's site along its frontage with Masterton Road, and again the implications of condition 5 could mean that wall has to come down. Maybe if I share the map again, if that's okay, I could maybe just articulate what I'm trying to say. Apologies. Yeah, so condition 5 requires a 2 metre wide footway along the frontage with Masterton Road, where the site meets it, which would be here, which again is a bit of a pinch point, and you've got this kind of traditional wall here. So I suppose my thoughts on it were that, you know, it might be more appropriate to have the pedestrian link through the site, either adjacent to the wall on the other side or just through the site, and then have it pop out through here. And again, in terms of this bit of stretch of road here, I'm conscious that there's not any traffic on that, because it goes to a dead end up there. So again, I suppose there's question marks as to whether or not it'd be reasonable to have the footpath there. But again, if the footpath wasn't getting provided to the south, there might be more of a weight given to the overall benefits of that connection by having a footpath link up there. But it was just my thoughts that instead of having this, if that condition required that wall to come down, it might be in everyone's interest to have the permeability through the site, either on the other side of the wall or some other way. That was all.
I'm not sure this is a matter that I can go into. It doesn't seem to appear to be directly related to the appeal, which relates to conditions 1D and 3.
I suppose it's 3.
The appellant have a
My view is
view on
that
that?
my view is I'm happy for the wall to stay and have the footpath inside. Absolutely, it's always been the village boundary, but the visibility at the far end, I think, is still fine. We've got a massive opening, but and there's no traffic, so I don't think it's an issue. But having said that, just by the nature of the wall, it's actually quite old. So if somebody started knocking things about, it might fall down anyway. But that is the old track cart. See where the gate is there? That is the old track cart into the steading as well. So that was the access historically into the steading. There were two. There was that one and the other one at the other end. So it would be perfectly fine to walk out that way. It doesn't even need to be on the frontage. You could walk out that way.
And maybe there's maybe scope within condition 3, because it does say shall be upgraded between the site frontage.
Yeah.
So the site frontage could be taken as from this point rather than at the point to the south, in terms of where condition 5 comes in. So it was just to raise that, if that was within the scope.
Yeah.
Okay, I'll give it some thought. I think we may be going beyond what is reasonable for me to address through this appeal. Nothing to stop both parties having discussions beyond the remit of the appeal. Okay, is there anything anybody else wants to say in relation to condition 3? I think that's been a helpful discussion, and I've certainly got a number of points to think about in terms of a way forward in relation to that, to address the matters raised in the appeal. Everybody happy to move on? Okay, just one minor matter, and again, it just comes to the sort of the procedural implications of potential outcome of my thinking. So the appeal as submitted, which Mr. Fitzpatrick helpfully clarified for me, relates to conditions 1D and 3 of the 2023 planning permission in principle. So if the appeal is allowed, including where subject to varied additional or deleted conditions, a new permission is not created. Instead, the decision would alter the existing permission. So under section 48(1) of the 1997 Act, I can reverse or vary any part of the council's decision, whether the appeal relates to that part or not. So if I go beyond changes to conditions 1D and 3, I am able to do that. but should I intend to do so, I'm required under section 48(3) to give notice of my intentions and invite the council and appellant to make representations. So my understanding is that I would need to follow this procedure should I decide to make any changes to or remove conditions 10 and or 11, as we discussed in relation to if we go down the minded to grant route. Obviously, if that would also apply if I look at condition 5 as well, because that wasn't part of the appeal. Now, I think the purpose of that part of the Act is to allow the appellant to take stock once they're aware of the intentions, and if they consider that it would result in a worse position for them than the current position, then they could withdraw the appeal. And then existing permission 23-00739 PPP would remain. So that's because if once I issue a decision, if it's it'll be a different that permission will no longer stand. I know you have the 2022 one, but the 2023 would remain. Does either party wish to comment? Is that your understanding of procedurally where it may take us, and is there anything you want me to take into account? Mr. Fitzpatrick?
Would that also include us having clarity in advance on the relative greenfield brownfield division?
No, I think what I would be needing to do would be to run past you what I'm tending to do in relation to conditions that are that you haven't referred to in the appeal. But I would do this in advance of formally issuing the notice of intention. So I suppose once you get the notice of intention, I'm not necessarily looking for comments. You know, I would, in relation to the procedures under section 48, I would formally contact both parties and say, look, I'm intending to vary matters that don't form part of the appeal and give you the opportunity to comment before I actually finalise the decision notice. At the notice of intention stage, the decision goes out. But if the appellant decides not to progress it, then at that stage you would be aware of the decision, and you could then, I suppose, withdraw it, or you could would be there. So it's an unusual one procedurally, you know, just trying to work out the different steps. But certainly that's my understanding. I wouldn't be issuing I wouldn't be seeking your views on the full decision in advance, but to say you would have the notice of intention. You would to take a view on if you felt then that the existing permission was suited your needs better.
Yeah, that's great. That's accepted from our side of things. Yeah.
From the council's point of view, is that your understanding of the?
Yeah. Well, no objections to that. I suppose one question would be that would we just see the conditions that you're seeking to change, or would we see the full suite of conditions, which might take account of the conditions that you're?
No, I think it's just that I have to seek your views on the ones that I'm amending or removing that aren't part of the appeal. So it would be, based on our discussions today, the ones that would come into effect would be 10 and 11 and 5, if I consider that to be necessary. I think anything that relates specifically to 1D and 3 are part of the appeal. So it wouldn't be a rehearsal of what I'm thinking. It would be very much a narrow opportunity to comment on that certain part of the procedure. But say once the notice of intention is out, then the if we go down that route, I mean, that's not. I've a lot of thinking to do before I work out albeit I've got to get past the first basic as to whether or not contributions in principle are required. So there's various steps for my thinking to go through, and by having these conversations, I haven't preempt my judgment on those. I'm just trying to be clear procedurally that I don't trip us up by not following the requirements of the Act.
Yeah, I suppose it's just whether or not we can give proper comment on what you're proposing with those other conditions if we don't know how the conditions that are within the scope of the appeal are going to be potentially altered or changed to deal with that. So, but I think I think our positions are clear on those conditions that might fall within the scope of what you're describing. So,
yeah, that's it. It's quite a narrow procedural remit to follow, and say I think I'm certainly I've got a lot of other things to weigh up before we get to that. But I just wanted to make sure that there wasn't anything that I was missing from either party's point of view on that procedural step. Okay, that's me got to the end of the agenda. Is there anything else that anybody feels I've missed on those matters that please say now if
No, I think it's been very comprehensive and covered everything.
okay, so that completes our discussions. Thank you all very much. It's been really helpful. I don't think I could have got through that doing it by written submissions. It needed that ability to drill down and have the discussions and make sure that that I understood where both parties were coming from. And say I don't think I could have done that with the written submissions. But so all the evidence I've heard today, I'll take account of. Alongside all the written evidence that I have. Say, depending on the outcome of my considerations in relation to that section 42 or section 48, I may need a further procedure, but I don't envisage that it would take long. The target date for the appeal is the 4th of May, and so I still envisage being able to meet that or being close to it, even if I do need to come back and seek representations. So that's what I'll be working towards. Any further questions?
no.
Okay. So thank you very much. We'll leave it here, and you'll hear from me in due course via the case officer.
Thank you very much.
Okay.
Thank you.
Thanks very much.
Bye.
Bye.
Bye.